Compensation for your power of attorney. It's a little bit of a touchy subject. Are they entitled to it? And should you even allow it in the first place? Now, this can create an issue where, let's say we have a blended marriage, or where we have someone who's not a child of the principal stepping into that position, the principal being the person whose document we're talking about, or, heaven forbid, a complete third party in the mix. Those are cases where all of a sudden compensation becomes a very, very touchy subject. So, for today, let's discuss both the financial and the healthcare powers of attorney. Should we pay them, and how much? But before we get any further, please be sure to like the video, subscribe, and let me know down in the comments if you've got any topics you want me to cover. But for now, let's get into it. Let's start with your financial power of attorney, and in there, the person is called an attorney in fact. That's the person we're giving authority to. So the question is, are they even entitled to pay in the first place? Well, to figure that out, we've got to look at California Probate Code Section 4204 to learn more. Section 4204 tells us that an attorney in fact is entitled to reasonable compensation for services rendered to the principal as attorney in fact, and to reimbursement for reasonable expenses incurred as a result of acting as attorney in fact. So with that, the answer is yes, but with a stipulation, reasonableness, and a distinction, compensation versus reimbursement. So let's start with that stipulation, reasonable. So with that, we need to define reasonableness. In many areas of the legal field, not just estate planning, we hear the word reasonable often used to define standards that we know can fluctuate due to a multitude of factors. Because we often cannot define exactly what one should do in every scenario, we do have to rely on people's best judgment, both when the action is performed and, if necessary, later when we analyze the soundness of that action. Reasonable is not a set standard, but is how we determine whether we met the standard of care, by which I mean, did the person, in this case the attorney in fact that we're giving authority to, did they perform an action that an ordinary, reasonable, or otherwise prudent person would in the same or similar circumstances? And that's generally how we look at reasonableness. When it comes to compensation and whether it is reasonable, we're generally looking to make sure that it's fair for the circumstances. We know we should be fair, but what do we even pay them? In cases like this, as long as the pay is fair and reasonable based on what work the attorney in fact actually needs to do, generally a fixed percentage or an hourly charge equal to that of an average bookkeeper in the area should do us fine. Every case is different, however. More complicated work would likely mean higher compensation is more reasonable, like something closer to 1 or 2% of the assets under management. However, if the work is less complicated, maybe paying a few bills a month and just forwarding things over to an accountant to prepare some tax returns, then a lower fee would be warranted in that situation. However, going a little bit further, keep in mind, you can set the fee. You can always fix the fee for your attorney in fact under your financial power of attorney, maybe just a fixed dollar amount per hour, a fixed percentage, or even go so far as to say no compensation whatsoever. That brings us to the next question though, should you even pay them in the first place? So again, touchy subject, depends on the circumstances and what work they can reasonably be expected to perform. In my opinion, it's generally a good idea to pay your attorney in fact, especially if they're not already your child or they're just a third party. The point of having a power of attorney in place is to pick people you trust and to pick people who will actually do it. Ideally, they would do it for love, but this is the real world. Real world means real world problems. People are going to have to miss work, they're going to have to sacrifice time with their family and spend a lot of time with you. So we don't want you to be left out in the cold. We want to incentivize people to stick around above and beyond the goodness of their hearts, of course. Now, that brings us to reimbursements. As a reminder, the probate code said that reasonable reimbursements is automatic. They can receive it. But you can always explicitly disallow that in your financial power of attorney. Generally though, in my opinion, I think it's a really bad idea to disallow reimbursements, as doing so would really push people into not accepting the position in the first place. Like I said, they might have to miss work. They're probably going to use up gas to chauffeur you around. They might have to buy you things, and they might cover a bill here and there in order to avoid missing a deadline. If reimbursements are prohibited, then making it that much harder for them to do their job makes it more likely that you're just going to be left without somebody there to help you. Now again, reimbursements, they must be reasonable as well. Repayment for gas for chauffeuring you around, that's very reasonable. Repayment for dinner that they bought for you and a friend of yours, I still think we can find that to be a reasonable reimbursement. Repayment for dinner where they brought a drinking buddy that you just maybe happen to know, it's probably not reasonable in that scenario. How about repayment for flights where your power of attorney flew out their whole family in order to come visit and help you? Definitely not, especially if they're deciding to go on vacation while they're in town. Let's shift gears a little bit to your healthcare power of attorney. Under that document, the person we're giving authority to is called an agent. So the question is, do we pay them? Well, again, we would normally want to look at the California Probate Code, but in this case, it's actually not explicit about compensation and reimbursements for agents. Healthcare powers of attorney are generally narrowly focused to just medical decision, while financial power of attorneys are broad in scope, unless we specifically narrow them to be limited. Thus, in this case, since the probate code is silent on the matter, we need to look at our general principles with regards to agency law. And that brings us to no compensation and reimbursement for reasonable expenses being allowed. So, for example, paying a fee at the pharmacy or paying a copay, I think that's a reasonable expense that we can allow. Maybe gas for chauffeuring you to and from doctor's appointments. I still think we can argue that that's reasonable, but frankly, in my opinion, I don't think we should push it beyond that. But that brings us to the next question. Should you pay your healthcare agent? In my opinion, I think we need to leave it at the general agency principles, no compensation, but allow reimbursements. You don't want someone making a life or death decision or a medical decision on your behalf if they will be getting paid more for keeping you alive. But with that, let's bring these all together. Under your financial power of attorney, compensation is generally allowed, but it must be reasonable for the circumstances. Reimbursements are also generally allowed, but must be for reasonable expenses they incurred as a result of their duties as attorney-in-fact. Now, you can always disallow either or both of those, but I recommend to allow compensation and limit it if you would feel more comfortable, but always allow reimbursements. Of course, it would always be best to have a conversation with your attorney-in-fact ahead of time so we can kind of lay expectations to make sure that everybody's on the right page. Under your healthcare power of attorney, the probate code is not explicit, so we look to our general agency principles to guide us, which brings us to no compensation and reimbursements are allowed, but they must be reasonable. My recommendation is again to just stick with these principles. What do you think? Would you trust someone to manage your life for free? You got any horror stories you want to share in the comments below, or another topic you want me to cover? Let me know down in the comments below. Be sure to like, subscribe, share the video with anyone in your family looking to create their own power of attorney. I'm attorney Andrew Bethel, and I'll see you at our next meeting.